So hello, everyone. Thank you for joining us today and welcome to the Chamber Live, Reopening and Rehiring with Adam Mason from Mason Prado Mason, LLP. My name is Kaylee Worski and I am the events coordinator here at the Greater Sudbury Chamber of Commerce. Eastlink is happy to be sponsoring the Chamber Live series designed to help support businesses by providing an opportunity to learn and network with other entrepreneurs. Before I introduce today's guest speaker, I would like to mention that we will be recording this session today and adding it to a resource section on our website. There's also a Q&A box available, which Adam can read from directly to answer any questions during this presentation. Should you have any further questions after this webinar, please feel free to reach out to Adam. We will be sending out a follow-up email with the link to the recording as well as Adam's contact information and a short survey. Thank you again for all joining us today. Should there be any technical difficulties, just note that we appreciate your patience and thank you for rolling with us. We're so honored to have Adam Mason here with us today. In this presentation, we will look at relevant legislation applicable to reopening your business and the guidelines and resources available to you and the issues to consider regarding employees, health and safety, and the public. Adam, I'll now turn it over to you. Thank you.
Hello, everyone. I'm speaking to you from my office here in downtown Sudbury. I am a practicing lawyer, and the areas of law that I focus on are primarily employment law, estates, wills, powers of attorney, estate and powers of attorney litigation, corporate commercial, real estate, administrative law, and just general civil litigation. So what I've been asked to speak to you about today is mostly related to, or primarily related to, employment law. So here at Mason Prado Mason, we represent employees and employers. Obviously during this period of time, there have been a significant number of questions and issues surrounding employment law and how that has impacted the economy, employees, employers. And what I hope to be able to look at today during this webinar is some of the general principles, either through the governing legislation that employers, businesses, and employees need to look at and consider when you are re-entering the world, the business world, the economy, in light of the ongoing COVID-19 issues that we all face. So obviously this is by and large unprecedented in terms of the impact that this has had on our society. Obviously it's had a significant impact on the economy and how businesses have functioned generally. So we are at the point now where the provincial government is looking at staged reopening. So first and foremost, I'd just like to consider some of the issues facing employers and businesses over the coming weeks and some insight in terms of guidelines that have been provided to businesses from the Ontario government. So I would look, just as an overview of some of the things that I'm going to be looking at today. The first is what an employer's duties are and what employees' duties are when reopening a business, or just generally speaking in light of the current climate regarding COVID-19 and the obvious health issues that arise related to that. So I'm going to give you some insight into some of the guidelines and resources that the government has provided to businesses, and these are extensive. They're sector-specific things that individual businesses and employers can look to in terms of how their business is going to function currently. If you're not an essential service at this point in time, what are the things that you should be looking to when that day comes, when your business is allowed to reopen on an ongoing basis. Additionally, I'm going to look at some of the issues related to recalling employees, and some of these matters have come up prior to the closing of large sectors of the economy. And a lot of businesses have had to make obviously tough decisions starting in March or earlier. I'm going to look at some of the employment law issues, mostly related to the Employment Standards Act and temporary layoffs, and how to recall employees, and what issues might stem from that. I noticed that there's a panelist who's raised their hand. I'm not sure exactly what that, whether or not I can answer those types of questions at the moment. But the last portion of this webinar, I'm going to open it to the floor, and we're going to go through some of the questions that you have. There's a Q&A box through the Zoom applications, and that you can put questions to me through. And hopefully we can get through those, and I can provide you some insight nearing the end of this presentation. Obviously, one thing that I would like to emphasize is that I'm trying to provide general insight to a broad range of individuals, whether they be employers, employees, and that this shouldn't be taken as specific legal advice to some of the questions and concerns that you may have. Obviously, you should consult a lawyer if you have significant legal concerns that you need questions to, but I'm happy to answer some general questions as we move forward. So the first aspect that everyone needs to consider when we're looking at reopening businesses is the governing duties of both employers and employees. And this is dictated by the Occupational Health and Safety Act. And the Occupational Health and Safety Act was in effect before COVID, during COVID, and it will continue afterwards. The important aspect of this piece of legislation is obviously that the employer has certain duties and employees have certain duties regarding the businesses that they run. And the question that has come up often related to COVID-19 is that these duties are consistent and have stayed consistent, but the way in which an employer and an employee will function within the mandate of the Act has changed significantly. And this is the uncharted territory that we are in as a community and as a society generally regarding the impact of COVID-19. So there's been a lot of question marks in terms of how do we deal with this? What's the best approach? Obviously, the government is putting the health concerns of the community at the forefront of all this. And that's something that employers and employees will have to obviously keep in mind, the health risks involved in running a business on a day-to-day basis. But once that the stages of reopening start to move forward, it's important to keep in mind these types of duties. So the the Occupational Health and Safety Act provides an outline of a number of obligations that employers have, and I've highlighted, this is under Section 25 of the Act, and I've highlighted these specific provisions because of the way they can and likely will be interpreted in the context of COVID-19. So an employer shall provide information, instruction, and supervision to a worker to protect the health and safety of that worker. So one of the important aspects of the guidelines that have been coming out through the Ontario government and the resources that are there for employers is to keep in mind that it's essential to have a plan and a course of action in terms of how you're going to run your business in light of the obligation to keep employees safe and to keep the public safe while running your business. So it's important to communicate this with your employees to be able to come up with a plan. And these plans will depend on the type of business that you have. It'll depend on the size of the business. But it's essential that you consider all the potential points or risk involved in how your business functions, and what you can do to reasonably protect your employees and the public. So that leads me to the second point under 25 sub 2H, which is on the screen before you, that an employer shall take every precaution reasonable in the circumstances for the protection of a worker. So obviously, what was reasonable in the context of pre-COVID is not necessarily the same as it is now that we have a fundamental change in how people have been able to interact or not interact. And as you're, I'm sure everyone is aware, going to the grocery store, all of those types of things, there's been a clear shift in terms of the protective measures that are reasonable in the circumstances to provide a safe environment for employees and for customers. So it's essential to keep in mind that and the employer has to take every precaution to try and keep their employees safe, but that it needs to be reasonable in the context. And I'm going to look at some of the resources that are available to different employers, which helps to provide insight on what actually is reasonable in the circumstances. But as I mentioned, every employer, it'll be different depending on the type of business that you run. It'll be different in terms of the number of employees that you have and how much contact you might have with the public on a regular basis. So keeping this in mind, there's obviously a duty on employees and workers to make sure that they're abiding by the Occupational Health and Safety Act, so the requirements of the Act. And this is under section 28 sub 1B, that the use and wear equipment, protective devices, or clothing that the worker's employer requires to be used or worn. So obviously, the general requirements that existed before COVID-19 have shifted in terms of what can be reasonably asked of employees in terms of keeping them safe and keeping the public safe when going about the everyday business. So there's obviously an obligation to report any potential issues. The employee has to make the employer aware of certain potential hazards or defects with equipment or within the work environment generally. And I'm going to get into a bit more detail in terms of what that might mean regarding COVID-19 issues that could arise once your business is reopened. So one thing I would like to highlight is, and we'll send out this PowerPoint so you have these resources available to you after the fact, but the Government of Ontario has provided a number of detailed guidelines and resources in terms of what it is a specific sector or business should be expected to do, or what they can do to help protect themselves, their employers, or their employees, and the public. So obviously, it's beyond the scope of this presentation to go through all of the potential resources that are available to every type of business sector that's out there. But if you can see on the screen here, they've put these resources out based on different industries and sectors. So construction, food processing, restaurant and food services, agricultural, mining. So there is an extensive amount of different types of resources that are available depending on what type of business or what type of business you run or what type of business you work for. So these are detailed and extensive in terms of what potential guidelines should be considered when restarting your business. Or if your business has been open as of today under the first phase of the reopening plan. So given that it's June 2nd and the extent to which or what stage of reopening, when those second and third stages are going to come through, this is obviously a subject of debate, and I'm not going to try and look into the future to see or make any guesses as to when the second stage will start. The first stage of reopening came about on May 19th, and the government allowed for certain businesses to reopen in a limited capacity. Obviously, retail services, some outdoor seasonal and recreational services. And with that in mind, the workplace safety and prevention services, these are the guidelines that ultimately you can look to in terms of sector-specific considerations that you should be looking at in terms of the type of business that you have. So obviously there's an obligation on the employer to report potential illnesses, and on the employee if they have concerns over COVID-19 contraction. So what the employee is obviously encouraged to look to health resources to be able to get tested. And if an employee does have signs of COVID-19 contraction, then obviously they should be sent home, and the employer needs to take the types of precautions that are reasonable in the circumstance to, one, determine what other employees might have been affected by these issues or by the other potential employee, and if the public has been potentially exposed. So with that in mind, there are obviously certain competing interests in a situation where your business has been reopened and there's a concern that you have an employee who may be have contracted COVID-19. So that issue brings up obviously privacy issues for that employee, which an employer needs to be aware of and needs to consider in terms of what information they're providing to other employees. So the employer has to keep the private information of the employee private, but at the same time, there's an obligation to make it known to the other employees that there is a potential risk there. So under the Occupational Health and Safety Act, under Section 43, there's obviously a right of an employee to stop work if there's a serious or a real risk that the workplace is unsafe. So with that in mind, it's obviously important in a situation where there is a concern that an employee may be ill and the effect that that has on other employees, to inform them of the potential risk. And obviously the way that the employer is going to deal with this will depend on the size of the business. There's obviously a duty to investigate if there's a concern regarding an illness in the workplace and the effect that that'll have on the public. So these are all things that should be incorporated into any type of plan that an employer has in terms of what they should be looking at when they want to reopen their business. So with that in mind, a lot of the guidelines and the resources for employers is based on common sense by and large regarding what we've heard about every day with COVID-19 issues. You know, training everyone possible on transmission routes, and providing hand sanitizer, making sure that there's adequate physical distancing between employees and between employees and the public, where all of that's possible, are considerations that should be included in any plan that you would have set up when you're reopening your business. With all of these things in mind, limiting the number of people in the workplace brings with it its own challenges, obviously. The extent to which an employer will be able to bring employees back or create a new shifts in terms of how many employees are going to be in a space at one time. All of these issues are things that are going to need to be considered before starting the overall reopening process. And if you haven't, if you are reopened and you haven't thought of all these potential issues, it's just important to potentially look at these guidelines, because they provide you some guidance in terms of a lot of the things that you might not have even thought of. So high-risk areas within the workplace, and providing maybe additional attention to an area where there's a lot of traffic. There's potential, risk of the area becoming contaminated, and cleaning that area on a more regular basis than you would generally speaking. And obviously, a lot of these guidelines have provided that personal protective equipment is something that can be very effective depending on the workplace, but they've described it as essentially a last resort in terms of the overall plan that you should have. Obviously, it's something that makes people feel a lot more comfortable, especially when you're dealing with the public. And it reduces the risk if you're wearing PPE that you might expose someone else. But at least at this stage, it's not a legal requirement that everyone in your workplace be fully garbed in PPE when you're reopening your business. But again, I'd like to emphasize that the employer has to take every precaution that's reasonable in the circumstance. So the prevalence of types of face masks that are now being produced and available, and a lot of the type of shielding that's being produced and available. And I believe the Chamber of Commerce has some resources on local businesses that are providing that type of service to businesses, that it's pretty reasonable in the circumstances of what's been going on generally, to have access to some face masks for employees and to have those available to potential customers if need be. Obviously, it'll depend, again, and I don't want to sound like a broken record, it'll depend on the size of your business, the type of workplace that you have, the size of the workplace, and how many customers or members of the public you are interacting with on a regular basis. So with that in mind, if you're in this, if you're in the first stage and you've reopened your business, or if you're preparing to reopen your business because you're anticipating the next step of the reopening, keeping in mind that at least at this point, it's unclear when that's going to happen. And I know that there's been some discussion as to whether or not there will be regional reopening. Obviously, locally, the situation in Sudbury in terms of contraction rates is somewhat less than it is in other parts of the province. So whether or not that's going to happen, obviously, these things change on a day-to-day basis. And it's something that everyone should consider when they're reopening or making a plan to reopen their business. So one of the main things that has came up in March when the state of emergency came in was that a lot of employers made the tough decision to temporarily lay off employees. So if you are in a unionized environment, the relationship between the employer and the employee is obviously subject to the collective bargaining agreement, and that'll govern the method by which and what the employer's obligations are in light of recalling employees. So obviously that's important to keep in mind. The other thing that needs to be at the forefront of any considerations regarding recalling employees is any employment contract that you may have as an employer with an employee. One thing that is available or that's highlighted under the Employment Standards Act is the temporary layoff provision. This is under Section 56. So I'd like to emphasize that under common law employment considerations, an employer does not have the unilateral right to lay off an employee unless it's specifically agreed to in the employment contract. So that obviously creates some issues related to the extent to which employers have had to lay off employees starting in March or earlier. And these are the types of issues that you're going to need to pay special attention to when recalling employees. So the Employment Standards Act provides for a number of situations where what's defined as a temporary layoff, where there's no notice or severance payable in that type of situation. What that means essentially is you can lay an employee off for 13 weeks in a period of 20 consecutive weeks or a period of 35 weeks within a period of 52 consecutive weeks if a number of the statutory provisions are met, and this would include paying benefits throughout the period, or if the employee receives supplementary employment benefits if the employee is being paid during that period, or if the employee is a non-unionized employee, the employer recalls the employee within the time set out in an agreement that was made between the employer and the employee. So these are all things that you need to consider when you come up with a reopening plan. Is one, whether or not as an employer, you have the capacity to recall all of your employees once you're deemed an essential service, or at least maybe a better way to phrase that is once your business has been allowed to reopen under the tiered reopening system that's been proposed. So those are obvious considerations that come up when you're dealing with recalling employees. There's obviously certain issues that will come up in the sense that If your business is reopening, but you have been working from home, and you want to shift your business back to the model that you had pre-COVID-19. Where an employee needs to stay home for a number of reasons, including potentially taking care of children, all of those types of things, the employer would need to accommodate the employee up to undue hardship. So the specifics of when that duty to accommodate will come up, it depends. But the prevalent thought is that if you've allowed employees to work from home, clearly it's not undue hardship to continue an employee to work from home, if they have a legitimate reason to do so. If the reason that an employee does not want to start working out of an office setting or out of the workplace pre-COVID-19 is that there's a perceived risk of infection of COVID-19, depending on the situation the employer is in, that might not meet the standard of allowing them to continue to work from home. So this will obviously depend on the type of situation the employer's in. If the risk is because of a potential contraction from another employee or a member of the public, that's one thing. But if it's just that an employee is concerned about a general potential for contraction, that might not meet the standard where the employee can refuse to return to work. So if an employee is being recalled and from a temporary layoff, and they refuse to work or refuse to come back to work, within that context, there could potentially be viewed as having quit their position. Obviously, there's an obligation on the employer to clarify exactly whether or not an employee is actually quitting or not. But to kind of double back to what I had referred to at the beginning of this section of the presentation, while the Employment Standards Act outlines certain situations and guidance on what constitutes a temporary layoff, under the common law, an employer doesn't have the unilateral right to lay off an employee temporarily unless it's baked into the employment contract and the agreement between the employer and the employee. So this will obviously depend on a number of factors, including how the employee may have been temporarily laid off. But there's always the risk that it'll be framed as a constructive dismissal. And then in that context, notice or pay in lieu of notice would be owing to an employee. But it's important to keep in mind that any employee has a duty to mitigate their damages, which means that they have a duty to continue to try and find work. And in that situation, if they're refusing to come back to work and they're claiming constructive dismissal, in a number of circumstances, that would be a failure to mitigate by not accepting the job back and going back to work. This is obviously, and I'd like to emphasize that this is obviously subject to the particular factual situation that an employer and employee are in. And there are a number of other considerations that obviously come up when we're talking about the issue of constructive dismissal. But the important thing is to bear in mind, and it has been in terms of when an employee may have been temporarily laid off. These are considerations. it's obviously important to be forthright with the employees in terms of the situation that everyone seems to be in light of the state of emergency that came up. And the impact this has had on the economy and employers' ability to continue to keep people on an ongoing basis. So it'll depend on what the employer and the employee have agreed to prior to the layoff, and all of these things are important in terms of what employers' plans and businesses need to consider before they're able to reopen and before they're recalling employees. Having said all that, I think it might be important, maybe before bringing up the issue of questions, is that there has been a number of legislative amendments in the recent months to respond to a lot of the concerns that people, employees, employers have had due to the issues related to COVID-19. So obviously, the extent of the relief that has been provided by the federal government has created a different situation than in the normal course, where an employer is considering laying people off or having to terminate employees because of economic concerns. So we don't know the extent at this point how courts will consider all of these factors in a situation where we're talking about constructive dismissal or any of those types of considerations. One thing that I wanted to emphasize that I may have left out from earlier is that one of the amendments that the Ontario government has put in under the Employment Standards Act relates specifically to unpaid leave related to COVID-19. So if an employee is showing signs of an illness and they need to be sent home, the unpaid leave provisions that have been added under Bill 186, which came into effect March 19th, is that there's job protection for an extended period of time related to health concerns surrounding COVID-19. And this does include concerns related to either quarantine, self-isolation, or because an employee is providing care or support to an individual referred to in Section 8. So as Section 8 deals with a parent, step-parent, a child, stepchild, and if an employee is providing care or support for one of those individuals, and that's not the complete list, bear that in mind, because of a matter related to the designated infectious disease that concerns that individual, and the new legislation states, including but not limited to school or daycare closures, that would essentially provide them with employment protection in a situation where these provisions are triggered. So these are unpaid leave provisions, and it's always important to consider what type of benefits and resources employees have under any benefit plans or anything like that, or what the contract says in terms of paid sick days. All of those things are need to be considered when you're considering the impact of employees who may become ill, and the impact that has on your business, on the other employees, and the public in general. Having said all that, I see we have a couple of questions here. And I'm wondering if Kaylee can maybe bring some of those up.
Absolutely. So I'm not sure if this is a question or a comment, but somebody writes, options to not have employee return due to business downturn.
Options to not have employee return due to business downturn. Okay, yes. So I'm assuming this means that the business is in a tough financial situation, and you're facing the unfortunate reality that it's difficult to maintain your business with the number of employees that you had. So as I mentioned, the temporary layoff provisions are one thing to consider, but there's always the risk there that it'll be considered constructive dismissal if the employer doesn't have the right to temporarily lay off an employee based on a collective agreement or an employment contract. So there's always that risk involved there. I think in light of the fact that there has been EI and the CERB and a number of those potential issues that have come up, or potential resources that have come up for employees, and just the reality that, the list of essential businesses that were able to stay open, throughout this entire period was relatively small. Compared to all the businesses that needed to shut down. A lot of employers have tried to at least discuss these matters with their employees, and the employees were able to, were willing to agree to just, go on temporary layoff and receive benefits through EI or payments through EI or through the CERB. So, those are two methods, or that's one method to consider if the employee is willing to do that. The other is if you have the unilateral right in an employment contract to temporarily lay off an employee, then as long as you're doing that in compliance with the Employment Standards Act, and I alluded to those briefly, it'll depend on, it's based on the length of the layoff. That's a potential option. When it's a temporary layoff, there's no requirement to pay to provide notice or severance. That's subject, obviously, to constructive dismissal under the employment standard or under the common law. So there aren't a lot of good options in terms of when you need to reduce staff or potentially lay people off. And if you are reducing staff and your only option is to terminate an employee, obviously you need to be aware of the requirements under the Employment Standards Act in terms of notice, and depending on the size of your business and the length of time the employee has been there, severance. But there's also common law notice that can be above and beyond what is owing to an employee if they're terminated under the Employment Standards Act. So I don't know if that totally answers the question, but those are some options that you can consider.
Perfect. Another question that we have is, can you force employee to take vacation, use their vacation time?
Okay, so the Employment Standards Act dictates that vacation is to be taken in whole week blocks, unless it's on agreement with the employee. So to take a day off here or there. This is, again, and I don't mean to harp on this too much, but this is obviously subject to any employment agreement that you have with the employee that'll govern. So I don't want to speak to every possible possibility. It'll depend on the employment contract that you have. But under the ESA, ultimately, it's up to the, if we're talking about the 1 week blocks, it's ultimately up to the employer to determine when the employee can take time off. Usually in the normal course, it'll be something that you try to agree on with the employer and the employee. If we're talking, say, 1 day a week, that'll have to come down to and there has to be some type of agreement between the employer and the employee for that to be possible. But at the end of the day, if we're talking about who has the ultimate say in terms of when an employee can take vacation time under the law in Ontario, it's the employer.
Great, thank you.
Subject to a number of caveats, but that's the baseline.
Wonderful, thank you. Another question we have employees that have taken an unpaid leave of absence in the hospitality business. We are not unionized. What are our rights in calling them back and they do not want to return?
So what are your rights in terms of, as an employer when calling the employee back? So first and foremost, it's obviously going to depend on what triggered this unpaid leave of absence. And the Employment Standards Act sets out a number of different requirements in terms of how long those can last, what obligations the employee has. But if it's an unpaid leave of absence, it needs to be considered within the context of those provisions under the Employment Standards Act. And just for ease of reference, I'm just going to pull up. So leaves of absences are governed by Part 14 of the Employment Standards Act. And it's obviously beyond the scope of this webinar to speak to every situation: family medical leave, organ donor leave, family caregiver leave, critical illness, child death leave, crime-related child disappearance leave, domestic or sexual violence leave, family responsibility leave, bereavement leave. It outlines very specific obligations of an employer in those types of situations. But if the time period within which an employee can take those types of leaves is up and the employer wants to recall the employee, again, subject to confirming and providing clear notice to the employee that you're intending to recall them, and that if they don't return to work, you'll take that essentially as they've resigned their position. To force an employee to come back to work, I mean, obviously, an employee can quit a position depending on the amount of time that they need to give in terms of notice. But when that time frame is triggered will really depend on the type of leave that we're discussing here. So I can't, unfortunately, give you more clear insight on that at this point.
Great, thanks. On to the next question. What do you do if an employee does not want to identify as high risk? Example, severe asthma, compromised immune system. How do you accommodate without violating/respecting their privacy or their wish to not disclose?
To me, that seems like a situation where the employer is making certain assumptions about an employee, which obviously brings with it certain problems. If an employee is not providing, their particular health situation, they generally don't have an obligation to disclose those types of things to an employer, especially if they're not asking for an accommodation in that type of situation. So again, I would think that in most situations, the employee is the one who's bearing the risk of potential contraction in that type of situation. If they're requesting accommodation, but not providing a reason for why they need that accommodation, obviously that puts the employer in a tough position. But if it's due to health-related illness, I mean, they need to provide some insight as to why and how you could possibly accommodate. So, I mean, to some extent, you're walking a tightrope in terms of respecting the employee's privacy and providing some type of accommodation. But if you don't know the extent to which you need to accommodate the employee and what it is they need in terms of accommodation, obviously you need some information to be able to do that job and meet your duties. And if the employee is just saying that they need accommodation generally without providing any insight as to why that might be, an employer can ask for some more detail on that to actually do what they're required to do under law to accommodate an employee up to undue hardship.
Great, hope that helps. One last question. Due to COVID-19, we now work from home. As an accounting staff, we need to get access to our files, but prevented from entering from the premises. Is this reasonable under the circumstance?
So obviously there are competing interests involved in that type of situation. If you legitimately can't do your work, do your job because you don't have the resources or you don't have, plain and simple, the material that you need to accomplish your tasks, you should draw that to your employer's attention. And on the other hand, obviously the employer is concerned that you want to reduce the potential risks to other employees. And if it's kind of blanket allowance for employees to come into the office to pick up what resources they need, it defeats the purpose of setting up a system where people are working from home. So I think with a lot of these things, it's a balancing between what the employer's obligations are in terms of keeping individual employees safe. But at the same time, an employee, if they need to be able to do their job, if that's what they're being required or asked of. So I think it's a discussion and a plan and a course of action. And I mean, these are difficult conversations to have. Obviously, it's not always easy as an employee to bring these issues up with your employer. But I think employers at this point, and given that we're in unprecedented times, need to be aware of issues that they just potentially haven't thought of. And as an employee, it's important to do that in a respectful way, where you're bringing up a legitimate concern and that it's something that needs to be acknowledged and resolved. Reasonable in the circumstances will depend on how how an employer deals with that, whether or not it's having a designated employee who can manage the physical resources and making sure that employees have access to that sort of stuff. It'll depend on the employer and the situation that they're in particular. So I hope that answers your question, at least in part. It's the kind of thing that the more detail would provide maybe a clearer answer, but I think it's a discussion that's at least worth drawing attention to your employer, that obviously you need certain resources and that they should be open to discussing ways in which they can get that stuff to you.
Wonderful. Thank you so much, Adam. As our time draws to an end, I'd like to thank Adam Mason for joining us today to provide some guidance on reopening and rehiring. I would also like to thank our attendees for their participation. We hope you found this webinar helpful. If you have any questions about how the Chamber can assist your business, please don't hesitate to reach out to one of our staff. The Chamber has developed a COVID-19 resource page on our website to help inform you during this crisis. Visit our website at sudburychamber.ca to learn more. And please watch our social media feeds for more webinar topics in the coming weeks. Thank you and have a great day.
Thank you, everyone.